The Supreme Court's decision in McDonald v. City of Chicago was about the Second Amendment right to keep and bear arms and the incorporation of rights into the 14th Amendment. It was a follow-on to the Supreme Court's decision several years earlier in Heller v. District of Columbia. The Heller decision left several questions unanswered, one of which was the issue of incorporation. In other words, the Second Amendment itself, like everything else in the Bill of Rights, applies only to the federal government. But is this right to keep and bear arms something that also applies to the state and local governments? Is it one of the things that's incorporated into the 14th Amendment so that it applies to the states and the cities and counties? In Heller, the Supreme Court didn't have to address this, because that case was about the gun laws of the District of Columbia, and that's not a state, it's a special federal district. So Heller was essentially a case about the unconstitutionality of something that the federal government was doing. As soon as Heller was decided, it was obvious that the incorporation issue was going to come up. The court had struck down the District of Columbia's handgun ban, and there were a few cities that had similar laws banning handguns, particularly the city of Chicago. And so right away, people filed lawsuits saying that Chicago's law was unconstitutional. And those lawsuits presented the incorporation question. The District of Columbia couldn't ban handguns anymore. Was that also true for every city, county, and state across the country? And if you think about it, it's a pretty important thing. Imagine if you're an advocate for gun rights and you see the Heller decision and you're happy about that. You think, well, that's great. Gun rights are now secured. But then if someone said, oh, by the way, that case really only protects you fully if you happen to live in the District of Columbia, any state or local government can still take away all your guns, well, that would be a pretty dramatic disappointment. In other words, Heller's impact would be significantly undercut if the right is not incorporated. So this gives us an opportunity to review a little bit about incorporation. The Supreme Court gradually, over the course of the first part of the 20th century, incorporated most of the provisions of the Bill of Rights. They debated back and forth about what approach to use. A few judges, like Hugo Black, favored a total incorporation approach, where they just incorporate the entire Bill of Rights into the 14th Amendment in one fell swoop. Other judges preferred a fundamental rights approach, where the judges would get to pick and choose which things are really important enough to be considered part of what it means to receive due process under the 14th Amendment. They also debated whether a right should be incorporated jot for jot, which means the right would mean exactly the same thing within the 14th Amendment as it does in the Bill of Rights. So you'd have exactly the same right no matter what government is involved. Or instead, might you have different standards? Might a right get stronger protection under the Bill of Rights than the 14th Amendment, or vice versa? Ultimately, the Supreme Court went for a selective incorporation approach, which combined selectivity with the jot-for-jot incorporation of rights. So, not everything in the Bill of Rights is incorporated, but if something is incorporated, it's incorporated completely in the jot-for-jot way. The bottom line is that the Supreme Court, having chosen that selective incorporation approach, wound up using it to eventually incorporate almost all of the Bill of Rights. The First Amendment, freedom of speech, religion, the press, that's fully incorporated, so it all applies to the state and local governments. The Second Amendment, well, that's what McDonald is about, so we'll come back to that in a moment. The Third Amendment is a question mark. The Supreme Court just hasn't ever ruled on it one way or the other. The Fourth Amendment, it's about governments doing searches, that's incorporated. The Fifth Amendment, most of the Fifth Amendment has been incorporated. The rights against double jeopardy, the right against self-incrimination, the takings clause, that's all been incorporated. But the Fifth Amendment also has one thing in it that's not incorporated. That is the clause requiring grand jury indictments for certain criminal cases. The Supreme Court has had many opportunities to incorporate that provision, and they have declined to do so. So if federal prosecutors want to charge you with a felony, the Fifth Amendment requires them to go to a grand jury and get an indictment. In other words, a grand jury of regular people will be assembled, and the prosecutors will need to convince them to vote to indict you. But in state court, you won't have a right to a grand jury. And so the prosecutors can bring charges against you just by preparing a charging document called an information or complaint or accusation, and just take it directly to a judge and say, here, this guy's charged with the crimes listed here. The Sixth Amendment gives you a bunch of other rights in criminal cases. You have a right to counsel, to get a speedy and public trial, to have an impartial jury, to be confronted with the witnesses against you, and all of that's incorporated. The Seventh Amendment is not incorporated. It basically gives you a right to a jury trial in civil cases on common law claims for more than $20. Again, the Supreme Court has had many opportunities to incorporate this, and they've declined. So let's say you've got a tort claim against somebody, or a contract claim, or you're the plaintiff or defendant in some other civil litigation. If you're in federal court, you've got a right to try the case to a jury. If you're in state court, you don't have a constitutional right to a jury, and you might wind up with a bench trial where there's a judge and no jury. The Eighth Amendment has been incorporated as well, including its provision banning cruel and unusual punishments, excessive bail, and excessive fines. For the Ninth and Tenth Amendments, the issue doesn't really come up. The issue of incorporation isn't really relevant to them. They're somewhat strange provisions that don't really give any specific rights to individual people. The Ninth Amendment says that people may have other rights that aren't listed in the Constitution, but it doesn't say what they are. The Tenth Amendment says that the federal government has only the powers given to it in the Constitution, and all other powers retained by the states and the people. And those are interesting and important principles or concepts, but they're not really specific rights that it makes sense to say are incorporated or not incorporated. So the bottom line is that most things are incorporated. And notice that you've got two things that definitely are not incorporated, and I think you can probably imagine why they are not. They're both things that are very procedural in nature: the method of charging in criminal cases and the mode of trial in civil cases. And they're both things that would be somewhat burdensome to impose on the states. They'd have to start making people show up to be on juries in civil cases and on grand juries in criminal cases. In other words, they involve a bit of hassle and cost for the states. So with all that in mind, they've got to decide in the McDonald versus City of Chicago case whether the Second Amendment right to keep and bear arms should be incorporated. And frankly, that should have been pretty much a slam dunk issue. The question would be whether the right to keep and bear arms is fundamental. Is it fundamentally important enough to deserve to be incorporated? And you could certainly argue that either way, but if you read the majority opinion in Heller, it seemed pretty obvious that those 5 judges, who were the majority in that case, were going to say that this is a right that's fundamentally important. All 5 of them were still there on the court when they decided the McDonald case, and it just seemed quite obvious that they'd say the right was incorporated. There could be some good arguments for not incorporating it, but they'd be pretty much the same arguments for interpreting the Second Amendment in a narrow way that were already rejected in Heller. So it seemed like pretty much a no-brainer that the right would be incorporated, and probably by the same 5-4 vote as in Heller. But things got a little more interesting because of the litigation strategy that the lawyers bringing the McDonald case chose to pursue. Again, all they really had to do was just walk in and say, Heller already made it clear that the right to keep and bear arms is a very important right, so it's fundamental and it's incorporated into the 14th Amendment's Due Process Clause. Done, case closed. But the lawyers bringing the case decided to be a little more adventurous. They decided, hey, while we're at it, rather than just getting this right incorporated, why don't we try to overhaul American constitutional law in a much wider way? They said, why don't we use this case as an opportunity to have the Supreme Court overrule the slaughterhouse cases? Wouldn't that be exciting? You remember the slaughterhouse cases from way back in 1873. They were about a monopoly on butchering in New Orleans. That was the Supreme Court's first significant opportunity to interpret the 13th and 14th Amendments. And one of the key things they did was to interpret the 14th Amendment's Privileges or Immunities Clause in a very narrow way that left it a very insignificant provision. They said that it only protected privileges and immunities of U.S. national citizenship, and that's a narrow set of things relating to the federal government or federal lands or seaports or navigable inland waterways or protection from pirates on the high seas. As a result of the slaughterhouse cases, all of the attention had shifted over to the 14th Amendment's Due Process Clause. And it was the 14th Amendment's Due Process Clause that was used for incorporation of things from the Bill of Rights. And it was the 14th Amendment's Due Process Clause that was used whenever judges needed a location for a right that isn't really explicitly stated in the Constitution. They found liberty of contract in the Due Process Clause back in the Lochner era, and they found a right to privacy in the Due Process Clause in cases like Griswold, Roe v. Wade, and Lawrence v. Texas. So the Due Process Clause wound up being used for all that stuff, incorporation and substantive due process, because the slaughterhouse cases had ruled out the use of the Privileges or Immunities Clause, so they pushed all that stuff over into the due process arena. And a lot of people think slaughterhouse was wrong. They think that the Supreme Court interpreted the Privileges or Immunities Clause way too narrowly. And then it warped all this future development of constitutional law. by pushing things into the due process clause that don't belong there. So these lawyers said, hey, let's encourage the Supreme Court to go back and fix this mistake. Let's argue that the original intent of the Privileges or Immunities Clause is that it was supposed to be a really important and broad provision that protected all rights that are really fundamentally important for people to have. And the Supreme Court will go for that because they like originalism. They'll overrule the slaughterhouse cases, and they'll say that the 14th Amendment's Due Process Clause doesn't actually incorporate anything from the Bill of Rights. It's the 14th Amendment's Privileges or Immunities Clause that does that. And they'll say that it totally incorporates the Bill of Rights, the whole thing. We'll finally have total incorporation of the whole Bill of Rights. Now, the lawyers pushing for this were primarily conservatives, the libertarian kind of conservatives in particular. But they got some surprising support from the other side of the political spectrum. Some liberal law professors and progressive legal organizations jumped on board and said, yeah, let's overrule slaughterhouse and revitalize the Privileges or Immunities Clause of the 14th Amendment. Now, these liberals weren't encouraging this because they care about gun rights, and they didn't really care about the incorporation aspect of it at all. Instead, they started pushing for this because they thought it would ultimately benefit the kinds of rights that they favor, especially privacy rights. In other words, they want to have a constitutional right to birth control, to make decisions about abortion and sexual conduct. They don't want to see cases like Griswold or Roe v. Wade or Lawrence v. Texas get overruled. And they worry that the Due Process Clause isn't really a great, stable home for those constitutional rights, because of the whole dilemma surrounding substantive due process. And can you really have substantive rights in a procedural provision like the Due Process Clause? And so the liberals' hope was that if slaughterhouse got overruled, all of those cases and rights from Griswold and Roe v. Wade and Lawrence would get transplanted from one place to another. They'd be like flowers growing in a garden, and you realize, oops, these are in the wrong place. They're in the due process part of my garden. I'll gently dig them up and move them over to the Privileges or Immunities part of my garden. And once they're in the right place, they'll really thrive, and they'll grow to be healthy and strong. And there'll be much less of a chance that judges who don't particularly care for this kind of flower, like Antonin Scalia or Clarence Thomas, will ever be able to come along and destroy them. So if this worked, it could be a pretty neat trick for these liberal folks. It could essentially amount to creating a more solid, originalist basis for having a living Constitution approach. And so you wound up with a strange alliance of some right-wing and left-wing people, and they were all asking the Supreme Court to overrule slaughterhouse and find that the right to keep and bear arms is protected against state and local governments by the 14th Amendment's Privileges or Immunities Clause. It all sounded great and very clever until the oral argument began. The lawyer for the McDonald side got up first to argue, and here's how it went.
Mr. Chief Justice, and may it please the Court, although Chicago's ordinances cannot survive faithful application of due process doctrines, there is an even simpler, more essential reason for reversing the lower court's judgment. The Constitution's plain text, as understood by the people that ratified it, mandates this result. In 1868, our nation made a promise to the McDonald family. They and their descendants would henceforth be American citizens. And with American citizenship came the guarantee enshrined in our Constitution that no state could make or enforce any law which shall abridge the privileges or immunities of American citizenship. The rights so guaranteed were not trivial. The Civil War was not fought because states were attacking people on the high seas or blocking access to the Bureau of Engraving and Printing. The rights secured by the 14th Amendment were understood to include the fundamental rights honored by any free government and the personal guarantees
of course, this argument is contrary to the slaughterhouse cases, which have been the law for 140 years. It might be simpler, but it's a heavy burden for you to carry to suggest that we ought to overrule that decision.
Your Honor, the slaughterhouse cases should not have any stare decisis effect before the Court. The Court has always found that when a case is extremely wrong, when there is a great consensus that it was simply not decided correctly, especially any constitutional matter, it has less force.
What injustice has been caused by it that we have to remedy? Meaning, states have relied on having no grand juries States have relied on not having civil trials in certain money cases. They've relied on regulating the use of firearms based on the court not incorporating the Privileges and Immunities Clause in the way that you identify it. So in which ways has ordered liberty been badly affected?
Justice Sotomayor, states may have grown accustomed to violating the rights of American citizens, but that does not bootstrap those violations into something that is constitutional.
Are you saying that the rights, if you could clarify your conception of privileges and immunities, am I right in thinking that to keep and bear arms would be included even if we had no Second Amendment as you envision privileges and immunities?
Justice Ginsburg, that is correct. The framers and the public understood.
Just tell us the dimensions of what it is. I mean, we have the Eighth Amendment, so I know you say that's included. Keep and bear arms would be included even absent the Second Amendment. What unenumerated rights would we be declaring privileges and immunities under your conception of it?
Although it's impossible to give a full list of all the unenumerated rights that might be protected by the Privileges or Immunities Clause, just as it's impossible to do so under the Due Process Clause, at least with respect to the Privileges or Immunities Clause, we have wonderful historical guideposts. There are.
Mr. Gurr, do you think it's at all easier to bring the Second Amendment under the Privileges and Immunities Clause than it is to bring it under our established law of substantive due process? Is it easier to do it under privileges and immunities than it is under substantive due process?
It's easier in terms, perhaps, of the text and history, the original public understanding.
No, I'm not talking about whether the slaughterhouse cases were right or wrong. I'm saying, assuming we give the privileges and immunities clause your definition, does that make it any easier to get the Second Amendment adopted with respect to the states?
Justice Scalia, I suppose the answer to that would be no, because.
And if the answer is no, why are you asking us to overrule 150, 140 years of prior law when you can reach your result under substantive due process? I mean, unless you're bucking for a place on some law school faculty.
No. No. I've left law school some time ago, and this is not an attempt to return.
I mean, what you argue is the darling of the professoriate, for sure, but it's also contrary to 140 years of our jurisprudence. Why do you want to undertake that burden instead of just arguing substantive due process, which, as much as I think it's wrong, I have acquiesced in it?
Justice Scalia, we would be extremely happy if the Court reverses the lower court based on the substantive due process theory.
So it became clear very quickly that most of the justices were not interested in that approach to the case. It turned out there was only one justice willing to go along with overruling Slaughterhouse and revamping all of this stuff, and that was Clarence Thomas. He said, "I don't like this misuse of the Due Process Clause. Slaughterhouse was wrong, and I'd overrule it, and let's try to get this right." And that's consistent with his approach in general. He's the one justice on the Supreme Court who is the least concerned with stare decisis, the most willing to overrule precedent. But all of the others, even the other very conservative, heavily originalist judges like Antonin Scalia, didn't want to mess around with all of that. They said, look, Slaughterhouse has been heavily criticized, and it may be wrong, but that's all water under the bridge at this point. It's not worth going back and rethinking so much settled law. So it's a very cautious approach. It's influenced by the idea of stare decisis. And I'm sure it's also influenced by a simple preference for certainty over uncertainty. If they were to suddenly turn the Privileges or Immunities Clause into this super important provision, what would happen? Would abortion rights get stronger or weaker? What about economic rights? Would there be a return to a stronger protection of economic freedom like in the Lochner era? Who knows? So 8 of the judges basically said, let's just continue debating under the old rules and handle incorporation through the Due Process Clause. And Clarence Thomas was the only one with an appetite for radically rewriting constitutional law in this respect. Note that Clarence Thomas's position would raise some big issues, because the Privileges or Immunities Clause applies only to citizens, whereas the Due Process Clause protects persons. He included a footnote in his opinion about this, where he said that he wasn't going to talk about this aspect of it. He'd save that for another day. But it could make a big difference, not only for aliens, who are persons but not citizens, but also for corporations, who are considered persons but not citizens. The conservative members of the Supreme Court have been expanding constitutional rights, such as freedom of speech and political speech rights in particular, for corporations, and that might be frustrated by this. One of the other issues that came up in the case was what exactly the test should be for something to be incorporated, and that was kind of an interesting question. There were some times in previous cases when the Supreme Court made it sound like you should incorporate a right only if it's something that would be fundamental to any civilized, fair, just legal system. In other words, it's got to be something that no free country could ever do without. And that standard would be good for the city of Chicago, right? Because they could say, obviously there are quite a few civilized countries in the world today, in Europe or Canada or Australia, where handguns are very restricted. So it's possible to have a free country without a right to possess handguns. So therefore this right can't be incorporated. But the majority of the Supreme Court in McDonald rejected that standard. Even though there were previous cases that had phrased the test that way, the court said that really wasn't right. The standard is really whether a right is fundamental to our system of liberty and justice. Even if other countries may do fine without this right, the question is whether it's fundamental to the American version of freedom. There was one other thing about incorporation that got clarified in McDonald. I mentioned before that the Supreme Court had used the selective incorporation approach, and one aspect of it is that when you incorporate a right, you do it in a jot-for-jot manner, so that the right means exactly the same thing in the 14th Amendment as in the Bill of Rights. So the same tests, the same rules, etc. apply for any government action, whether it's federal, state, or local. But even though the Supreme Court had gone with the jot-for-jot approach, there was still some lingering uncertainty about whether that was absolutely the only way that would ever be allowed. In other words, even though the Supreme Court had used the jot-for-jot approach for lots of things, did that mean it was mandatory? Or would the door possibly still be open to incorporating a right in a non-jot-for-jot way if circumstances came along where that seemed appropriate? And Chicago wanted to argue for that here. The city said, hey, for this particular right, let's not incorporate it jot for jot. Even if a federal handgun ban, or a District of Columbia one in the Heller case, would be unconstitutional, let's not restrict every state and every city and every county that much. Let's leave them with a little more room for local preferences and experimentation. But the majority of the Supreme Court of McDonald said, no, everything must be jot for jot. And this is the most emphatic declaration of that the Supreme Court's ever made. Again, in the past, they'd gone with the jot-for-jot approach for lots of things, but they hadn't absolutely closed the door to doing it another way. But here they slammed that door shut. In a footnote, they talked about a case, Apodaca versus Oregon, that had seemed to be an exception to the requirement that all rights be incorporated jot for jot. That case had said that jury verdicts in federal criminal trials must be unanimous, but jury verdicts in state criminal cases don't need to be unanimous. So it seemed like an example of something that was not incorporated in a jot-for-jot way. The rule for the federal government was different. But the majority of McDonald said that that was really just a unique aberration. 8 justices in the Apodaca case thought that the right should be the same in both contexts, federal and state. There was only one justice, Lewis Powell, who wanted a different rule for federal versus state situations. So there was an overwhelming majority, 8-1, in favor of the jot-for-jot approach in Apodaca. It just so happened that the 8 justices who wanted jot-for-jot incorporation were split 4-4 on whether unanimous juries should be required. 4 thought unanimous juries should be required in federal and state, and 4 thought it shouldn't be required in either. And so, Lewis Powell was able to slip in the middle and make his opinion be the decisive one, even though he was the only one who had the view that it should be different in federal and state situations. Nobody else shared his view. So the majority here in McDonald brushes that aside and says, well, that's just a fluke aberration. Jot-for-jot incorporation is otherwise the mandatory only way to incorporate a right. The Supreme Court would later go on to overrule the Apodaca versus Oregon case and say that unanimous juries are required in all criminal trials, whether it's at the federal or state level. So once again, you get jot-for-jot incorporation all the way. Finally, the dissent by John Paul Stevens in the McDonald case was quite striking. This was pretty much the last thing that he had to say as a judge. He'd already announced that he'd be retiring at the end of the term, and this opinion was on the next to last day of the term, so it was the last major opinion that he'd be releasing. It was his swan song. He'd been on the Supreme Court for 25 years, so he'd seen a lot of major cases and developments in constitutional law, and the Supreme Court had changed a lot during his time there. It had become more conservative. Stevens was a Republican, and he was appointed by a Republican president, Gerald Ford. But Stevens wound up becoming the most liberal person on the court, and that was partly because he drifted to the left as a judge, for whatever reasons, but it was also because the rest of the court shifted to the right while he was there. So even if his ideological and political views had stayed perfectly constant, he would have seemed like he was relatively more liberal compared to new justices like Antonin Scalia or Clarence Thomas. He used his dissent in the McDonald case to explain what he thought about the close connection between the incorporation doctrine and substantive due process. In his view, they're the same thing. Incorporating things from the Bill of Rights into the 14th Amendment is really just one example of substantive due process analysis. It's all a matter of finding that important substantive rights can be protected by the word liberty in the Due Process Clause. And why do you think he wants to emphasize that point? It's not because he really cares about incorporation issues. It's because he likes the substantive due process cases, like Griswold, Roe v. Wade, Lawrence, and so on. So it's his opportunity to try to make a point to the conservative judges and to say, hey, do you see what you're doing? You're doing the same thing that you complain so much about. You want people to have a right to keep and bear arms. You think that Chicago shouldn't be able to ban handguns. But the Second Amendment doesn't apply to Chicago. And there is no other constitutional text that explicitly mentions guns or arms or anything about this. So what do? You decide that the Due Process Clause implicitly contains this right that you want people to have. Hey, okay, that's fine. If you think the word liberty in the Due Process Clause protects that substantive right to have guns, that's fine. But just remember this, the next time you complain about privacy rights and how substantive due process is terrible and how the liberal judges are just reading their personal preferences into the Constitution, remember what you did. Incorporating the right to keep and bear arms is substantive due process. So realize that you're doing the same thing and don't complain about it. So he's using the McDonald case, even though it's specifically about the right to have guns, to make a larger point about abortion and other privacy issues that have divided the court during his time as a judge. So there was a lot going on in the McDonald decision, both on the specific issue of the incorporation of the right to keep and bear arms and on larger, broader issues about interpretation of the Constitution.